Welcome back to the Blueprint Collective, the place where we talk honestly about what it takes to run a modern practice in the A&E field. If you've worked in architecture and engineering long enough, you already know this. The risk model is broken. D&C contracts didn't quietly change things, they rewired them. Today, I'm talking with Farrah Motley of Prosper Law about everything to do with contracts, how the D&C contract has changed the risk profile of architecture, and where you really need to be paying attention to make sure that you don't get caught out in your next agreement. Farrah, welcome to the Blueprint Collective. Could you start us off today with a little bit of an introduction into yourself and let us know how you ended up here today?
Yeah, sure. So I've been a lawyer now for nearly 12 years. In my early days as a baby lawyer, and then throughout the kind of last decade, I've worked for a number of different consulting firms, so architecture, engineer, a couple of builders as well, but in the engineering space, a couple of multinational engineering firms, as well as an international architecture firm as an in-house lawyer. And then about 5 years ago, I started my own law firm, primarily off the back of old employers in the AEC space asking to get a bit of extra help on the contracts and legal front. And it's gone from there. So I work with a lot of different consulting firms and disciplines across Australia now.
Awesome. Most leaders I know that the risk model is broken, but everyone still signs. So what do you think keeps them doing it?
From my discussions with commercial people within the firms and also the kind of leaders within the business, is really a commercial driver. They want the fees, they want to keep the revenue coming in. And then it can also be kind of the glory of the project. They might take on a project where they know, okay, the margin's tight, or we're willing to take a slight loss because we want to be able to market that we've been involved in this project and use it in some marketing collateral to potentially win some other projects. There might be a bit of an unknown with a client. They might go, well, we're willing to take on the risk for this engagement because it might lead on to other stuff, and this would be a really good one to get. And things can go wrong along the way. Sometimes it works out and sometimes it doesn't. That's primarily where I see they're willing to accept that kind of higher risk and those unfair contracts. There's also, and I've seen it happening more and more over the last sort of 5 years, where developers and builders, because they are themselves under tight contracts, they just don't want any gap when it comes to the consultants. So they just kind of give it on a take it or leave it basis. And they're not too worried about how the risks are different for architects and engineers. They're not on site necessarily daily doing all the things that the builder's doing. So leaders within those consulting firms is really being driven by money, the glory of the job, building those client relationships with new clients, and kind of setting aside those unfair contracts in favor of those other drivers.
Yeah, absolutely. And in my experience, I always felt like the risk is just being pushed downstream so far, and there's just such an imbalance between the developer's risk, our risk as architects and engineers, the builder's risk, and sometimes the client risk as well. I feel like a lot of that came from the D&C, the introduction of design and construct contracts. Do you think that has shifted it completely? What do you think the impact was of D&C on the industry?
Yeah, 100%. I think, a lot of the big construction firms, or sort of mid-tier, maybe some of the top tiers do, but mostly mid-tier and lower, they don't have their own internal design teams. And I think they feel a bit, taking on that D&C role out of their depth, because they are completely reliant on the architect or engineer to contribute to that design aspect. And, fair enough, they're concerned that if that's wrong, well, everything that's constructed off of that is wrong too. There's probably also been a tightening in the insurance space as well that's kind of led to that heavy reliance and pushing all that risk down onto the design consultants. I think as well, if it's between the builder and the design consultant, you've got a principal that's put some very intense expectations onto the D&C contractor. And, they're going to be held over the coals if they don't deliver on what's in their contracts and what they've promised. So they're just shifting all the risk down onto the consultants. And sometimes as well, they may not themselves hold professional indemnity insurance, but they should, because they're taking on that design aspect. And so they're going, well, we don't have that insurance coverage, but we're going to shift it down onto the design consultants that do, and make sure that, they've got all the insurance that we might need if the design aspect goes wrong, which from a risk perspective for the contractor, it's not a great idea. But also, it's just putting an exceptional pressure onto the architects and the engineers to cough up on their PI policy if something does go wrong. One other aspect I was going to raise as well is that, in the D&C contract space, there's a myriad of consultants in different design disciplines, and there's that real interweaving and collaboration, coordination that has to happen. Now, if one consultant is heavily reliant on another, so as an example, architect engineer might be very heavily reliant on the geotech. If their deliverable is wrong, it has this domino effect where every other design consultant's work that follows on from there is also wrong. And so what the contractors try and do is, and I've seen it happening more and more in the contracts, is to say, if your deliverable, if your design is wrong, and it could be because you've been negligent, but it could also be because some other consultant that we've engaged has done the wrong thing and architect hasn't picked up that the geotech's work is wrong, we're going to hold you all to account. And they're kind of, spreading the risk load across everyone so that, it's almost like every consultant's being held to account for every other consultant, even though they're not their sub-consultant, they have no direct relationship with them.
I've seen that happen a lot. And I feel like, in my experience, the client has always been like, well, you should have known. As an architect, you're an architect. That is your expertise. Your expertise isn't geotech or engineering. And the same for an engineer, right? How does then proportionate liability work?
Particularly in the New South Wales contracts, doesn't matter for Queensland because you can't contract out of it, but particularly New South Wales and some of the other states where you can contract out, I'll always, if I'm doing a contract review, I'll always qualify it to say that exclusion, where we're saying if someone else contributes, say 20% to the loss, by excluding proportionate liability, what you're saying is even though someone else contributed 20%, you're legally responsible for 100%. There's no kind of divvying up who caused what. How I'll amend that is to say, well, it only applies as between whoever the design consultant is and their own sub-consultants. Because yes, you are responsible. If your sub-consultants do something wrong and you don't pick it up, it's part of your overall scope. And therefore, that risk should sit with you. But where it's other consultants that have been engaged by the principal or by the contractor, or, maybe there's some survey information that someone obtained ages ago and gave it to you. If any of that is wrong, then it doesn't fall back on my client. It does get divided up in that way. I don't normally have too much pushback on those things where I'm trying to say, proportionate liability is only excluded between client and sub-consultant. And oftentimes I'll go a step further, and I see it in almost every client contract now where they'll say, you're responsible for all your deliverables, even if information we give to you is wrong or information that another consultant's given you is wrong. And then I'll kind of go over the top of it and I'll say, no, if anything we've been given is wrong, provided that it's not an obvious risk. It was really, even the geotech report to a competent architect, it would have been obvious that that was clearly wrong. Then I'll have this clause that says, there's certain information we can rely on. Fair enough if it's in draft or it's preliminary format, maybe not. But there's a list of information we can rely on. If any of it's inaccurate and as a competent architect, we couldn't have identified that it was wrong, we'll get a variation for having to amend our deliverables, and we're not responsible for it either. So I always find when I bring that up with clients, they kind of struggle to give a good justification as to why it shouldn't be in there. And so it does, you'd be surprised how often it does get accepted.
I should have put that in a few contracts myself. I feel like there is this kind of reliance of, especially in the architecture field, our risk is limited to our insurance, right? But I have seen that that's definitely not the case. Can you explain why that isn't the case?
It's not. Yeah. Just because I tell you, I've got $1 million worth of insurance, that just means as between me and my insurer's agreed if I do something wrong, they're going to pay out up to $1 million. But it doesn't mean that my exposure to my client is $1 million. That's just the relationship between me and my insurer. I've had this conversation several times, usually people that are, more junior in the field, but they'll say, oh, why have we asked for this clause? Because our liability is already limited. Look, they've got 10 million professional indemnity insurance. And I'll say, we're just promising we have that coverage. We're not saying that if something goes wrong, that's all you can recover from us. Then as well, I think, particularly since pieces of legislation like the Design and Building Practitioners Act came in, you can't even limit your liability under that. If you do something wrong on a class of building that falls within the Design and Building Practitioners Act, you're on the hook. So you better make sure you have some pretty decent insurance in place if something goes wrong, because you can't limit your liability for that. That kind of arose out of some of the building defects that happened around Sydney, but also the Grenfell Tower issue in London with the cladding.
The DBP is really tough, right? And for good reason. Do you think that firms, especially in the New South Wales context, are prepared for the level of risk that they're taking on in those projects?
It depends who the firm is. Across different firms, they have a very different risk appetite. I think most firms kind of look at it as, I just need to get registration and like tick the box to say, yeah, I could technically comply with the registration requirements. But it goes much further than that. And I don't necessarily think that there's a good understanding of how the DBP Act kind of applies or how it might apply in different scenarios. I've even had it where someone's asked, could I be held personally responsible? Like as a director of a company that's got registration, could I be held personally liable? And the answer is yes, because the way that they define the registered practitioner and et cetera, it's not the business or the company. It may well be the business or the company, but it's the person who's accepting responsibility for that work as well. So it's very harsh. It's very harsh. I think it's almost compounded the issues in contracts and the shifting of risk from, developers and contractors down onto consultants, because they're going, well, you've got all these responsibilities under this piece of legislation. So that's kind of set that minimum expectation now. And we're going to go even further than that when the minimum bar now is already pretty harsh.
Yeah, it's so high, right? Where do you see consultants, architects, engineers accidentally stepping outside of their cover or their responsibilities without knowing it?
I've often seen it happen where someone's trying to, help the client out. Usually it's all done with very good intentions. They're just trying to help out, another consultant's not done the right thing on the project, or they're being slow, or, holding things up. And I can do that for you. I'm just going to quickly, it looks basic, I'm going to do it. And then they're a structural engineer. It's not in their engineering discipline at all. And it's a complete stuff up. And ultimately it backfires, because they often do it with the intention of, I'm just helping out the client. And then lo and behold, something goes wrong because you didn't really understand that discipline enough to be able to help them. And then, a wall falls down or something like that. That's not great for the client relationship. So definitely seen that happen. Other instances where people kind of step out of their bounds, I actually think, and this has been quite a common thing now as well, where I've seen some clients are quite unsophisticated. Often it's not a contractor, it's the principal. And they almost do a bit of a reverse brief, but not really. So they'll put in the scope, it's pretty vague. They don't have a good understanding of what an architect does versus the structural engineer versus someone else. And they'll kind of just slap together a scope of work. And if the consultant doesn't go through it with a fine-tooth comb to go, well, actually, that's not me. I might coordinate with that discipline, but that's an engineering task and that needs to go to them. They might find themselves having to agree to the scope when actually they've agreed to undertake certain disciplines in there, which just should sit with someone else entirely. And so that has come up quite a few times over the last few years where, principals, they just don't have a great understanding about who should be doing what and where that interface between the different consultants happens.
Yeah, absolutely. Why do you think so many consultants see negotiation as friction rather than protection?
It's a thing when you're given a contract and there's $1 million fee in there and you're starting work and you want to start invoicing and getting paid as well. And then you've got to go, but actually the contract you've given us is not what we thought it would be. It's having those hard questions right up front. And I think there's a reticence as well, because lots of consultants, they don't want to be seen to be difficult. They don't want to be seen to be, if we go and get a proposal from these guys and we engage them, they're going to ask for all these changes and, we're going to have a bit of an uphill battle. I have to say though, I've never, apart from one time where I actually suspect it was an excuse and actually that they went with another consultant, but I've never had it where a contract's fallen over or, the client's pulled the engagement just because they've said, hey, we need some changes here. We need the scope amended. We need these other contract amendments. It's a hard conversation to have up front, particularly when, from the business's perspective, it's driving revenue, driving profit, building the business. It seems like it's antithetical to that objective. I don't think it is, though. I look at it in a different way. I've had it where we've put in quite a few changes to a really bad contract. And actually, by having the discussion about why certain things are in there, it actually helps both the client and the consultant really get clarity on what will be happening going forward. And if there are misunderstandings, those get ironed out straight away, rather than that misunderstanding happening mid-project and it being a real pain point then. So I think it's actually much better for the relationship, have those hard conversations up front, and then you're both going to have clarity. You know exactly where you stand. What objectives do you want to be met? Don't leave it to the consultant to try and second guess what you might want. And so by having those discussions about those clauses up front, everyone gets much greater clarity on what it is that we're supposed to be doing.
Yeah, that's awesome. I've always seen people just be like, oh, if we don't sign, we won't win. And yeah, to me, it was just used to make the hairs on my neck stand up. We do a lot of competitions. We do a lot of bidding against other firms, and we always get that contract kind of really early, and we might be one of 3 or one of 5. And they're like, do you agree to all the terms and conditions? Is there a workaround for that in that kind of bidding process?
I always there's 2 approaches I'll take. So some of the tender submissions, you have to fill out a table. And if you don't be very prescriptive about what clause and how you want it changed, you basically speak now or forever hold your peace. So, you've got to be prescriptive then. But as an example, if there's 10 clauses talking about fit for purpose, because they usually, scatter the same obligation across a 100-page contract, instead of amending every one of those 10 clauses and just having this bulk page just for one issue, I'll kind of bunch them by issues. And then I'll say, clause XYZ, XYZ, this is how we want it changed and why, just to shorten it, because it's that visual thing where if you get a really big document, you'll go, oh, or I'll do like catch-all clauses going, notwithstanding this issue, actually this applies, just to shorten it. And then the other piece is where they don't mandate really specific comments in the tender submission, I'll just put in, I'll give my clients like a blurb that they can put into their fee proposal. And it basically says something like, we've received your contract, this form, we agree in principle to sign up to it, but we're going to need to address these kind of concepts. And it might be, the limit of liability, the amount of professional indemnity insurance we're giving you, what information we can rely upon. So I won't spell out every single amendment that I want. It's more just introducing those concepts, but saying that we're not saying we're not going to sign it. We're saying we will sign it, but before we do that, we need to discuss and address these issues. And then it doesn't put a bad taste in the client's mouth, because they're probably getting the same comments from other consultants. You're not giving them a 20-page document of changes.
Yeah, absolutely. That's such a good note. Do you see any differences in how new architects or founders of new companies versus kind of old school directors approach risk?
It's funny, because if I look back at the different companies I've worked for, I don't necessarily think it's an age thing or a generational thing. I actually think it's whether they themselves have been involved in a project where things have gone horribly wrong and they've had to be working till 11 o'clock at night to get emails from 5 years ago and meet with lawyers and affidavits and just all that nightmare stuff, or just having constant, calls from the client because they're unhappy. If you ever have to get involved in legal proceedings when something on a project goes wrong, it is not nice for anyone. you're not billing the time, you're just doing really long days for essentially the love of the stress of doing it. I don't think it's a generational thing. From my perspective, when I've seen someone take a fair risk appetite, not being too harsh on the contract and shifting the risk back onto the client, but being fair, being commercial and reasonable, is those ones that have been involved in some court proceedings, and they've kind of had a taste for, okay, this thing that seemed really minor at the time blew up into a really big problem. And as a result, I had to spend, 6 months of my life working for not much benefit.
Yep, I feel that. That leads me on to a good question. What's the process if something goes wrong? What should firms do? What happens? Could you explain that a little bit for us?
Yeah, I'll probably start with what not to do, because I've seen this happen too many times. Again, where someone's just trying to be nice and keep the client relationship. Do not say, oh yeah, I know we did do that wrong. Oops. Do not admit, even if you look at it and go, yeah, we've stuffed up. Don't admit it. Just say, we're going to look into it. Don't do anything. Go straight away, talk to the insurer. You've got to tell them. Because if you say something, again, lots of people don't realize this, you have this overriding obligation in that, particularly the professional indemnity policy, where you have to be completely transparent with your insurer. At the end of the day, they've promised to pay money if something goes wrong and you're getting sued. So they want you to be as open and frank with them as possible. Even if it's not, oh, we've got a claim, it might just be, we've just become aware that we might have stuffed up on this project, just so they have the heads up, because it just preserves all your rights under your insurance policy. Because if you go ahead and go, yeah, I've stuffed up, and you spend 6 months going back and forth with them trying to negotiate something and it doesn't work out and things escalate even worse than they would have been had the insurer been involved early, the insurer can actually refuse to cough up the money at all. Because let's say, well, you haven't been reasonable in trying to protect our interests. You should have told us straight away. And then usually with the less severe ones that I've been involved in, you don't admit liability. Go to your insurer and you say, hey, there's this issue, just making you aware, but we're going to try and resolve it commercially. More than 50% of the issues that I've been involved in, it didn't go through insurance at all. We still told the insurer, but they said, right, we're going to fix the work that we've done and pay for the issues to be rectified, because that's a lot less of a cost to the business. Rather than make a claim on our PI insurance, we'll fix all of that. We're not going to charge you for it. And then you're going to sign a deed of release and we're done. So that's kind of the best way to deal with those issues. But yeah, I've seen it a couple of times where someone's gone, yeah, oh yeah, it looks like we've done the wrong thing here. And I had one where they actually hadn't. They had done all the right things. It was a complete other issue, but they'd already kind of put their hat on the table and said, yeah, I think it was my fault. If consultants are wanting to strike a good balance between getting the job and having a good relationship with the client and risk, is to really kind of pick your battles. And it's not even a one size fits all. Like there might be a project where there's a particular risk on that project. And it might be, these consultants don't get on well. This is a high risk project because it's being built over a rail track or something like that. You should look at it through the lens of what risks are there in this particular project and then pick your battles. Like I've seen some consultants where they'll pick on like a modern slavery clause and get really stuck on it. It's not high risk for the industry, not high risk on that project. Pick your battles. You don't have to give a 20-page amendment list, but pick the battles. And, I think they'll have a much better outcome.
Excellent. Farrah, thank you so much for your time today. Just before we wrap up, is there one piece of advice that you think everyone should hear?
One piece of advice, read the contract before you go and submit variations, or read the contract, make sure everyone's across the scope so you can identify when there is a variation. I just see it time and time again on projects where it gets to the end and the fees have blown out and it's really pinched. Whereas if along the way, everyone in the team had a really good understanding about what the scope was, what wasn't in the scope, and how to get a variation, they would have had a lot more success on the commercial side on the project.
Absolutely. I have one more question. Do you think that more people in the chain of a project, so I'm talking project architects, not just kind of directors, should have access to these contracts and read them and understand them?
Oh, absolutely. Absolutely. I mean, at the end of the day, if you've got a project director, it's one person, they can't possibly keep track of everything that's going on the project. And I think that the contract should be shared with everyone in the team. There's never really anything in the contract that's so confidential you wouldn't want staff members to know about. Surely they know what their rates are. It should absolutely be, almost like a kickoff, an hour, 2 hour session going, here's what we're obliged to do. Here's what we're not obliged to do and we're not going to do. And by the way, here's a cheat sheet on how to get a variation. You take it up the chain if you do for a decision to be made. But yeah, I think that would definitely help to alleviate some of the risk rather than it just sitting within one person in the team who's not necessarily across everything that's happening.
That's awesome. Farrah, thank you so much for your time. I really appreciate it.
No worries. Thank you so much.
If there's one thing to take away from this conversation, it's that most of the damage doesn't come from not knowing the risk. It comes from normalizing it, from telling ourselves it's a commercial reality, and from believing that speed matters more than safety, from assuming insurance will save us, or from thinking we can fix it later. The leaders who change don't suddenly become smarter. They just decide that absorbing the unlimited risk isn't the cost of doing business anymore. If this episode resonated, share it with someone who's currently weighing up a contract that they're uncomfortable with, or someone who keeps saying, we can sort it out later. That's exactly who this conversation is for. Thanks for listening, and make sure you subscribe to the Blueprint Collective on your preferred podcasting app.